Your Honor, my client wants me to go into certain areas of inquiry that ethically I run into some issues, but I also have a major strategic fear that's going to open the door. So by way of background, there was a call on this case made, excuse me, made to her aunt, where there were questions being made about.
I've reviewed the file and I know that phone privileges were revoked.
So
Go
my
ahead.
fear is, if I ask the question he wants to ask,
Okay.
I'm going to kick that door open the first morning of trial, and that seems like a lot of risk for very, very little reward. And I want that on the record because, as the court saw, my client was getting pretty animated about not asking those questions.
I was going to have a conversation with him about it.
So that's number one. Number two, I've tried to kind of talk to him about like impeachment on collateral issues. From a strategy standpoint, I'm also mindful of what this young woman just testified to.
Right.
So I don't know that yelling about a right turn or a left turn for 5 minutes is a great strategy decision. He's demanding me do it. I'm putting on the record. I do not think that's going to play well.
Okay.
But in order to keep peace and keep the pressure down on my side, these are my fears. And I haven't tried as many cases as the court has, but I understand how this woman looks to those people right now. And I don't know that the juice is worth the squeeze on some of these points. But he's adamant. He wants it done.
Okay.
I want to do it. But when the door's kicked in and evidence starts
they're gonna kick open.
by bringing up things.
It's called opening the door.
Correct.
What door about what? That's what I don't
To
understand.
open the door to other evidence.
Correct.
To other evidence of what?
The call to the aunt. That's not coming in as of right now. They wouldn't admit it right at this point. But when it comes up that you have the aunt's phone number, the door's going to be kicked wide open.
Can I say something?
Mr.
The
Killins,
reason
here's
why I wanna-
Mr. Killins. Here's
Reason
all.
why- Can I say
Mr.
something real
Killins,
quick?
just be quiet for a second, okay? Couple things. Number one, you're doing very well, but I'm seeing and feeling your frustration and your anger. All right, remember what you and I talked about this morning, right? Look at me. Remember what you and I talked about this morning,
Yes, ma'am.
right? I said to you, the state was going to give an opening.
I
You weren't
understand.
gonna like it. You did really great.
I understand.
I told you this young lady was gonna take the stand.
Yes, ma'am.
You weren't gonna like what she was saying,
You're right.
okay? I get it. I understand you don't like it. It's normal. It's normal
ma'am.
human behavior. But I can feel from here.
I seen when you looked at me.
I'm eyeballing everybody.
Yes, ma'am.
I can feel it. That's what gets me to look.
Yes, ma'am.
Okay? And so, if I can feel it, guess who else can feel it?
Everybody else.
The most important people in the room. The ones sitting in that box. Because they're the ones that are going to decide your fate.
Yes, ma'am.
Right?
Yes, ma'am.
So you got to breathe, my friend. You got to keep it down. Second thing I'm going to tell you. You're talking to somebody that while I wear a robe, defines myself as a trial lawyer. I have tried cases all over the
But
place.
can I say something real
No, I want you to shut your mouth and open your ears. Okay? It's a hard thing for everybody to do, including me, but just calm your brain for a second. Stop thinking about what you want to say and just listen to what I'm telling you. All right?
quick? Yes, ma'am.
You have a lawyer. He's a good lawyer. He went to law school. He passed the bar. He tries cases all over the place. He's young enough to be my son, so no, he hasn't tried as many cases as me, but he tries cases all over the place. I've known John for years, since before I became a judge, and I've had the pleasure of having him in front of me. Not here not to tell you to advocate for yourself, but I'm asking you to do what's right for yourself and listen to somebody that is seeing this from a lawyer's perspective with experience trying cases. Ultimately, he is going to do what you ask him to do unless it crosses an ethical line, which he could get in trouble if he crosses. But other than that, he's going to do what you are asking him to do, because at the end of the day, if you get convicted, he's going to still walk out that door.
Yes.
You're the one that's going to walk out that door.
Yes, ma'am.
Okay? So, listen to what your lawyer's telling you.
Yes, ma'am.
Here's what he's telling you. If he gets up on cross-examination and he asks this witness certain questions, it may then open the door. That's a expression. It's about what now evidence can come in that maybe before might not come in, what might now come in because of questions he's asked. Okay? That's what he's talking about when he tells you open the door. Okay? So he's being cautious and trying to explain to you why he doesn't want to do things. If you think it's a big deal for him to bring up that she says she made a left turn and you say, oh no, that's not what she did, she made a right turn. If you think that's a big deal for him to get into, he's going to get into it. Frankly, whether a shirt is burnt orange, or whether it's red, it really isn't going to affect. I'm giving you an example. It's not involved in this case. It's really not going to ultimately affect things in the great scheme of life. It's like one little detail that doesn't really matter. But if you think that's a big deal, he's going to do it. That's what he's trying to talk to you about. What's important to me is that I continue to be able to keep you in this courtroom. You have done nothing yet to cause me to remove you. But when I see you getting really agitated, and I feel it, I'm a very vibe person. I feel a lot of energy from people, and I'm feeling the energy. It makes me a little nervous that you may not be able to control yourself. And one of the ways you may want to keep yourself under control, maybe you take deep breaths, not loud, but deep breaths to yourself, and just keep yourself in your seat. There's a process. She gets to get directed. He's going to cross-examine her, and then she's going to get redirected. That's the way it goes. And same's going to happen if you take the stand or you call a witness to take the stand. Same process is going to happen. And I'm not going to allow anybody to interrupt you. Like I told you this morning, I don't expect you to interrupt anybody else. Got it? All right. The person you've got to talk to about what you want to do and not is Mr. Hackworth, not me. I cannot give you legal advice. Go ahead. What do you want to ask me?
And this here is something that I want to bring up. The only reason that I wanted this particular thing to be brought up was to show that she's lying. I didn't do that. And I didn't have no gun. But the phone number to her aunt's house, aunt address, and to her cell phone. Right here, I got this thing because
that's what he's talking to you.
Gave it to me.
That's what he's talking to you about opening the door to the fact that you had full discovery, and in that discovery there may have been information that listed the alleged victim's phone number, and that's how you obtained it. Be quiet.
With her information had black mark over it.
Be quiet, okay? And you got that phone number from some source, and that then there was a jail call that was made by your aunt where you were three-wayed in, which is against HCSO's phone
not
privilege.
Not his aunt, to her aunt.
Oh, to her
Sorry.
aunt, and you were in on that phone call, and there was things said. I don't know what was said. I haven't heard the phone call. I don't know that the state was planning on talking about it. We didn't hear about it in opening, but that's what Mr. Hackworth is talking about with opening the door. Whether you all want to do that or not, that's completely up to you. I'm just telling you. Your attorney is the one that's trying to give you advice on that.
And I was letting him know, because all my legal work that came to me before Ms. Couture put that motion in on my phone, I brought it up the first time before my phone rights.
All right.
Kentucky.
All right, we're past that. We got to get the jury. I got it. I got it. You want him to go there, you have that discussion with him, and within the bounds of ethics, he's going to do and ask the questions that you're suggesting for him to ask. But just be aware that it may open the door to a lot more information coming in on how you possibly got that phone number other than from the alleged victim. And if it does, then you're the one that made this call. He's warned you. You understand that?
And that I understand, but what I am trying to tell you, my legal work that was delivered.
You don't have to tell me. I
It's covered
represented
that
young
law.
men just like you for 23 years. I know how the discovery came in and how the discovery didn't come in. But I know that there were many pieces of discovery that I, as a lawyer, received that did have information in it that I was allowed to share with my client, and that my client did see. So even though something may have been initially blacked out, it doesn't always stay blacked out. I don't know what happened in your case. I don't want to know. I'm just the judge here. I'm just trying to get us to go through this trial without a problem and get to the end. This is your life, like you and I discussed yesterday morning. You have a good lawyer. You can either take his advice or not. Ultimately, it's up to you what you do with that. The only thing he can't do is if you ask him to do something that's unethical. But other than that, he's just trying to warn you. You either listen to him or you don't. That's completely up to you. All right?